Section 12, Legal Hotline Q&A, Arizona Commissioner's Standards, Requirements for Licensees. Introduction, Advertising Mistakes that don't feel like mistakes. Jessica felt confident after learning the advertising rules. She made sure her brokerage name was on her posts, avoided exaggerated wording, and disclosed owner-agent when needed. But then she started seeing how other agents marketed, and realized something important. Most violations don't happen because agents are trying to break the rules. They happen because agents think, this seems fine. This section focuses on real legal hotline scenarios where agents believed their advertising was acceptable, but under Arizona law, it crossed the line. These are the situations that feel normal in the moment, but can quickly become compliance issues. Advertising lists of properties. You must show the listing broker. A licensee regularly sends out a list of properties for sale to a neighborhood farm area. It looks clean, professional, and helpful. But here's the issue. Those listings belong to multiple brokerages. The question becomes, does the agent need to show each listing broker's name? The answer is yes. Under AAC R4-28502F, if you advertise a property that is subject to another broker's listing agreement, you must display the name of that listing broker in a clear and prominent manner. This catches a lot of agents off guard. For example, if Jessica sends a top 10 homes in Gilbert email and pulls listings from the MLS, she cannot just show the properties with her branding. She must also clearly identify the listing brokers for those properties. Another example is social media. If an agent posts, "Check out these amazing homes," with multiple listings, each one must include proper broker identification. This rule exists to protect ownership of listings and ensure transparency and representation. We buy homes for cash. Ads. A hidden violation. A broker works with an investor who wants to run a billboard that says, "We buy homes for cash. Call now," with a phone number that routes directly to the broker. It sounds simple. It sounds effective. But it's a violation. Why? Because the advertisement does not clearly identify that a licensed broker is involved, and it fails to disclose the brokerage name in a clear and prominent manner. Under Arizona law, advertising must not create the impression that no licensee is involved and must clearly identify the employing broker. This type of marketing is extremely common. Bandit signs, online ads, cash buyer campaigns, but they must still comply with advertising rules. Jessica realized that even investor marketing is still real estate advertising, and the same rules apply. Misleading language. The 2-year builder warranty problem. A listing in the MLS advertises a 2-year builder warranty. But in reality, there is no actual warranty being offered by the builder. The only protection is the legal requirement that builders correct defects within 2 years. Is that advertising acceptable? Probably not. Under AAC R4-28502C, a licensee cannot misrepresent facts or create misleading impressions. Calling something a warranty when it is simply a legal obligation can mislead buyers into believing they are receiving additional protection. This is a great example of how wording matters. Another example would be advertising brand new AC when the unit is actually 5 years old but recently serviced, or saying move-in ready when significant repairs are still needed. Jessica learned that accuracy isn't just about facts, it's about how those facts are interpreted by the public. Promotions and giveaways. When marketing becomes gambling. An agent wants to offer a drawing for a free trip to Hawaii. Clients get entries based on past transactions, and new clients can earn entries by completing a deal. It sounds like a great marketing idea. But it's likely not allowed. Why? Because Arizona law may view this as gambling, giving something of value, a transaction, for a chance to win a prize. Even though agents can give gifts to past clients or offer incentives at closing, tying entry into a drawing to completing a transaction creates a legal issue. Jessica realized that creative marketing must still stay within legal boundaries. Just because something is clever doesn't mean it's compliant. For sale signs, what's required and what's not. A licensee creates a custom for sale sign that includes the brokerage name and the agent's phone number, but not the broker's phone number. Is that allowed? Yes. Arizona law requires that the brokerage name be clearly and prominently displayed, but it does not require the broker's phone number. This is a common misconception. Many agents believe every detail of the brokerage must be included, but the key requirement is clear identification of the brokerage itself. Another important reminder, if the property is owned by the licensee, the sign must also include owner-agent, joint marketing. When partnerships cross the line. A broker wants to co-host an open house with a lender, title company, and other vendors. They plan to share advertising costs and promote the event together. Is this allowed? It depends. Joint marketing is generally permitted, but all parties must pay their pro rata share of the advertising costs. If one party pays more than their fair share, it could be considered a violation of RESPA. For example, if a lender pays for the entire event while the broker receives most of the benefit, that could be seen as an improper exchange of value. However, if all parties contribute equally and are equally represented in the marketing, it is likely compliant. Jessica realized that partnerships in marketing are not just about collaboration. They must also meet strict legal standards. Real-world example, the simple email blast. That wasn't an agent sent out a weekly email featuring listings, market updates, and a few hot deals. It looked professional and helpful, but it did not include listing broker names for the properties advertised. A complaint was filed. The agent had no idea they were violating the rules. They thought they were simply providing value. This is one of the biggest risks in real estate, violations that come from good intentions but incomplete knowledge. Bringing it all together. Every ad tells a story. Make sure it's true. Advertising is not just about getting attention. It's about communicating clearly, truthfully, and legally. Every listing, every post, every sign, and every promotion must identify the brokerage, avoid misleading language, properly represent ownership and involvement, follow Arizona statutes and rules. Jessica realized that the best marketing strategy is not just creativity, it's compliance. Because in Arizona real estate, the question is not just, will this get leads? It's also, will this hold up if Adri reviews it? Online discussion. 1. Why must a licensee include the listing broker's name when advertising other properties? Answer. To ensure transparency and proper representation, as the listing broker has a legal interest in the property and must be clearly identified to the public. 2. What is the biggest risk of using common marketing phrases like warranty or fully upgraded? Answer. These phrases can create misleading impressions if they are not fully accurate, leading to potential violations and liability. 3. Why can promotional giveaways tied to transactions create legal issues? Answer, because they may be considered gambling or an improper exchange of value, especially if participation depends on completing a real estate transaction.